This is Phoebe Taylor,
and Ann Hoover,
and we'll be covering the Yarborough Sally versus the Tennessee Board of Professional Responsibility case.
On October 15, 2009, Lori Knoll fell down the steps in her home. She died 5 days later. The medical examiner determined that Miss Knoll's death was accidental.
However, Miss Knoll's parents, Frances Rogers and Verl Bible, were suspicious of her husband, Adam Knoll's role in her death. After hearing a 911 call in which Mr. Knoll gave an unreasonable explanation for Miss Knoll's fall, the claimants decided to retain attorney Yarborough Sally and file a wrongful death suit against Mr. Knoll. Sally agreed to represent the claimants.
Almost 1 year after Miss Knoll's death, Frances Rogers and Verl Bible filed a wrongful death complaint against Adam Knoll, accusing him of killing Miss Knoll in order to obtain her life insurance policy of $1 million.
Sally then gathered expert witnesses and medical documents, including brain matter slides. She charged Rogers and Bible an excessive amount of money for these discoveries. She also asked for an unreasonable sum of money for her time spent on the case, which included preliminary work such as watching several hours of the 48 Hours Mystery series on television and internet research.
4 months later, in early January of 2011, Rogers and Bible sent Sally a formal letter releasing her from all legal responsibility in the matter, effectively terminating her. This was a result of Sally charging them excessive fees of over $132,000. Sally was very angry about this letter, responding with a letter of her own in which she stated that, "You are not the lawyer, I am."
After the claimants requested their file, Sally refused to release them all, claiming that Rogers and Bible still owed her over $80,000.
The claimants responded with complaints to the Board of Professional Responsibility. In their complaint, they claimed that Sally had refused to turn over files, medical records, and other items. Sally responded with a 21-page response to the board and continued to refuse to turn over the files. Sally's refusal forced the claimants to hire attorney Larry Vaughn in a civil action suit against Sally to retrieve the files. Vaughn filed a suit in the Knox County Chancery Court. This filing in the Chancery Court still did not convince Sally to overturn the files.
The Chancery Court proceedings ended in April of 2011 when the Chancellor demanded that Sally hand over all medical files pertaining to Miss Knoll's death.
Meanwhile, the Board of Professional Responsibility began to investigate claims made by Rogers and Bible against Sally.
In December of 2011, the Board of Professional Responsibility sought disciplinary action against Sally and concluded that Sally had violated Rule 1.16, subsection D, as well as multiple other rules of professional conduct.
In her argument before the board, Sally claimed that she had handed over all documents that she had not personally paid for to the claimants, such as expert witness testimony. She did not argue that she had not returned brain tissue slides for Miss Knoll's autopsy.
The claimants argued that Sally had sent them a package of only a few sheets of paper that they had already had copies of. They claimed that Sally's actions forced them to take materially adverse actions by having to hire and pay Mr. Vaughn to file a civil suit against Sally.
The Board of Professional Responsibility ultimately decided that Sally had violated Rule 1.16D and suspended Sally for 1 year and was subject to be reinstated upon proof of rehabilitation.
Sally filed a petition for a higher court's opinion and went to trial in April 2014. The trial court found sufficient evidence to uphold the panel's decision that Sally had violated Rule 1.16D by failing to promptly overturn materials. The court noted that she had admitted to withholding certain files until she was demanded to turn them over by the Chancery Court.
They also upheld all of the panel's other decisions regarding Sally's multiple rule violations.
The one mitigating factor in the trial was that Sally had no previous disciplinary actions.
Rule 1.16D, according to the Tennessee Rules of Professional Responsibility, states that a lawyer who is discharged must promptly surrender papers and property to which the client is entitled. Sally broke this rule by refusing to overturn relevant documents and materials upon request from Ms. Rogers and Mr. Bible and their new attorney.
In order to avoid this disciplinary action of suspension, Sally should not have taken on Rogers and Bible's case to begin with. Sally admits to also being counsel to 28 to 30 other cases at the same time of the wrongful death complaint. When lawyers take on this amount of work, it can lead to being unprepared. She also stated that she had never previously prosecuted a wrongful death suit.
Another way she could have avoided disciplinary action would have been to promptly give the clients all relevant files upon her termination, which would have enabled Rogers and Bible to seek their wrongful death suit with a new attorney.
And that concludes the case of Yarborough Sally versus the Tennessee Board of Professional Responsibility. Our sources include Westlaw and the Tennessee Board of Professional Responsibility rules.